Hello, everyone. This is Diva with the Diva Lawyers Social Club, and I'm here today to talk to you about the differences between the LLC, the corporation, and the partnership, and how each of these business entities can benefit you. So today I just want to give a general introduction to the basic business entities and how you can set one up. Basically, there's three main business entities that a person can form to conduct business or to hold assets. And I just wanted to give you all a brief rundown of the different types of business entities out there and what they are and what they can do. Now, these entities are available in most states, and each state has different laws and requirements for how to set up a business entity and how to keep such business entity maintained. So it's very important that you research your specific state laws about this topic. Visit your state's Secretary of State website just to get an understanding of what your specific state requires and the filing fees that your state charges and the annual fees that might be charged by your particular state. I am only licensed in the states of California and Florida, so I'm primarily only going to be speaking from the California standpoint when I give this video. And even though California is probably the worst place to set up a business entity, I'll talk about why a little bit later in the video. But most of the perspectives in this video are going to be coming from a California perspective. And it's just really important that you check out your own state's requirements if you're watching from a state outside of California to get up to speed on what your specific state requires. So with this video, I'm just going to be giving the basic information about the business entities, but please understand that there are levels to this corporate game, and the business entity area runs very deep. There's all kind of different things that you can do with a business entity and different rules that apply to business entities. But for today, we're just going to give the basic information and get past the first step. And that first step is, starting a corporation or LLC and getting positioned to be in that game. So I know many people will start their business as a sole proprietorship. Now, sole proprietorship is also known as a DBA or a fictitious business name. A lot of people who start to get into business will go register a fictitious business name with their county and start doing business under they'll register their fictitious business name under their personal name and under their personal social security number. And although when you're starting out, it might be okay and safe to run a business in that manner. However, it's usually not a good idea to run your business as a DBA using your own name and social security to own that structure. Running a business as a sole proprietor or under a DBA using your own name and your social security number is highly risky and offers very limited tax benefits. So two of the main reasons that a person will set up a business entity is to accomplish one or two goals or to accomplish both of these goals. One, for the limited liability against creditors that a business entity can offer to you, and two, so they can optimize the tax benefits of running their business and partake in some of the tax benefits that are offered to certain business entities that might not be available to a person who is operating as an individual person. So before I get into these factors, let's first understand that when you set up a business entity, you are creating another person that is separate and apart from you. So a corporation is a whole nother person, and there's case law that defines a corporation as a separate person, quote unquote, for all kind of purposes. So once you set up a business entity, as far as an LLC or a corporation, S corporation, C corporation, you're actually setting up a whole new entity and creating a new person that is going to be separate and apart from your own self. Um, so keep that in mind as we talk about these issues. Once those issues are in place, you're going to have a separate person that's set up that's going to have its own obligations and its own liabilities. So when you operate as a sole practitioner or a sole proprietorship, which is also known as a DBA or a fictitious business name, using your own name and your own social security number as the owner of the sole proprietorship, you're putting all of your assets and income at risk in the event that problems may arise while you're conducting your business. So, for example, say that you are a hairdresser and you have a hair salon business and you're curling someone's hair and you accidentally you have a slip of the hand and the curling iron burns their face and they've got this big burn mark on their face now. So, of course, they're probably going to go try to sue you for negligence and try to seek damages from you from causing that burn to your face. So if you're running your business, say the business name is Hair by Claire, and you're running this business Hair by Claire as a fictitious business name that's registered under your personal name and under your personal social security number, that person is going to come and sue you personally, even though you have a fictitious business name. You personally are still going to be on the hook for the harm caused to someone while running your DBA business, Hair by Claire. So that client is going to sue you personally, and then all of your income and assets are going to be open for that client to take if they are successful in securing a judgment against you for the burn on their face. And so, therefore, if you own your own house in your name, if you own your cars in your name, you have your bank accounts in your name, that judgment creditor is going to be able to come to you, sue you personally, and attach all of those assets. So this is why people often elect to set up a separate business entity that will try to shield their personal assets and income from creditors of the business. So also keep in mind that a lot of people say, oh, well, I just started this business. I don't have a lot of money. I'm actually operating at a loss. So I'm not really worried about someone coming to sue me for a burn on their face. They're not going to get anything. I'm judgment proof. I don't own anything. And my business really is not making a lot of money right now. Well, in California, most judgments are good for up to 10 years, and then they can be renewed after that 10-year period indefinitely every 10 years. So technically, a judgment creditor can keep pursuing you for an indefinite amount of time. So while someone might not have a significant amount of money at the time, you can sit on a judgment. The judgment amount will collect interest at the rate of 10% a year, and then you might come into some money 20, 30 years down the line, or your company might grow and now you're profitable, and then that person can swoop down with their judgment that now also has 10% of interest added to it every year and take all of your property. So just keep this scenario in mind as I proceed through this video, and as I progress through this video, we're going to discuss how business entities can be set up to protect you against that kind of scenario, and also discuss the potential issue concerning the tax benefits that various business entities can provide. Now, tax issues go super far and super wide. And if you've ever seen the United States tax code, you know that code is about 10,000 pages long. The lingo is very complicated, and I have an advanced degree in how to decipher the tax code. It still makes no sense to me when you try to sit down and read it. So it's really overwhelming to try to figure out the tax code and all of the various benefits that the tax code can offer. Um, and most people don't have time at all to sit there and try to figure all that out. But the tax game is very complex. It goes very far and wide. There's so many twists and turns in the tax arena that a lot of people just don't even have any clue about, especially when you get into business entities and estate planning and things like that. There's so many ways that you can twist and turn the game that most people are totally unaware of how the tax code can actually be deciphered in order to put you in a favorable tax position, um, and legally limit your tax liability if things are set up right. Um, so, as a business owner, you want to position yourself to receive the greatest, most favorable tax benefits possible. Because again, when you start off, you might not have a lot of income in the beginning, but over time, of course, you're expecting to turn a profit. And many times, business entities can offer various tax benefits that include net loss income carryback, net loss income carry forward, and all kind of other avenues to offset the profits, the future profits that your company might enjoy. So, so again, just in considering how you're going to set up a business, if you decide to start running a business or set up a business, the sole proprietorship is probably not the best way to go. There are some benefits in the beginning that can be afforded by running a business as a sole proprietor, but most of the cons about running a business as a sole proprietor um, usually aren't going to be favorable and aren't going to lead to the maximum benefits that a business entity can provide. Um, so, um, so when you operate your business as a sole proprietorship that is registered under your name using your social security number, all of the income that that business generates is going to be your income. um, you set up your DBA, you get money to come into the DBA, you take out the allowed expenses that your business might have, and then you're going to report that income on Schedule C of your 1040 income tax return. And that's fine because the Schedule C does allow for a number of business expenses that are also afforded to people operating as a corporation. However, you have to keep thorough records of all of your business expenses. You have to be able to prove that the expenses that you're taking are a necessary business expense. And then you have to keep track of all of those expenses and show that they are a bona fide business purpose for at least a period of 6 years in the event that you get audited. So you're going to have to keep receipts upon receipts upon receipts for everything that you do as a business owner, as a small business, I mean, as a sole proprietor business owner for up to 6 years. And that can get tedious. Most business entity structures will shift business income away from you, and you can usually streamline the business expenses through the entity business bank account and keep all of your business income and expenses separate. So, once you set up a corporation or an LLC, then again, remember we're creating a separate person, a separate entity that's separate and apart from yourself until it's linked through the tax structure. But the business income then is business income that stays in a business account, and everything is put in that business vehicle and is not intermixed with your own personal income and assets. Um, so now I'm going to talk about the different business entity structures and how liability and tax issues that I just discussed will come into play with each of these structures. I'm going to start with the corporation because the corporation is actually my preferred business entity of choice. And I generally like to operate through a corporate structure, even though I know a lot of people rave about the LLC. and they like to get excited about the LLC. We will talk about the LLC and why it is a good vehicle to set up, but personally, I prefer the corporate structure because corporations have been around for a very long time. The law concerning corporations is well settled, and the IRS recognizes the corporate structure as a separate entity, and most government entities are set up as a corporate structure, and the potential for tax planning and benefits, in my opinion, are just greater with the corporate tax structure, especially when we get into like dividend received income. That's actually income that a corporation can receive that is actually deducted from its other income as opposed to included in its other income. But that's one of those complex issues that gets deep into the corporate and tax game that I won't address in this video, but that's just something to keep in mind. Um, so for corporations, there's two main types of corporations. You have the S corporation and you have the C corporation. Most large companies like McDonald's and Starbucks and those kind of companies, most of them are organized as C corporations because a C corporation has the ability to have an unlimited amount of owners, which in the corporation structure, they are referred to as shareholders. So most C corporations have the ability to have unlimited amount of shareholders, and the shareholders are not limited to being U.S. citizens or U.S. permanent residents the way they are limited with an S corporation. Under an S corporation, the business is limited. Well, in California, an S corporation is limited to 100 shareholders, and those shareholders must all be U.S. citizens or legal permanent residents. So therefore, if you're not a citizen of the United States and you don't have a green card, what they call a green card, you generally cannot own shares of an S corporation. However, you can own shares of a C corporation in that situation. Um, Also, because the corporate, the corporation and tax structures are so complex, there's so many twists and turns that you can take with a C corporation, especially if you have the proper guidance and you know the various loopholes and benefits that can be afforded to a C corporation. I always find that the C corporation is the best way to go for certain purposes that we will talk about later on in the video. Um, so when you form a C corporation, well, you form a C corporation and you form an S corporation the same way. You file what is called Articles of Incorporation with your state's Secretary of State. I think it's called the Secretary of State in most states, but in California, it's definitely called the Secretary of State. You might want to check with your own state to see what they might call it, if they call that office something different. But I believe for most states, you will go with the Secretary of State for that state to set up a corporation. And it's basically a matter of filling out a couple of pieces of paper, determining how many shares you want to have authorized, and filing that paper with that Secretary of State. And then once you file that paperwork, you have your corporation in place. At that point, you'll go apply with the IRS for what is called an employment identification number, also known as an EIN. And now your corporate entity is set up and they have their own personal social security number, which is referred to as the EIN number. Um, the next step you have to take in order to set up an S corporation is that you will then file what is called a Form 2553 with the IRS, and that form will transform your C corporation into an S corporation. And then that's where you get into how many shareholders you are allowed to have with the S corporation, and how you can operate as far as an S corporation goes. Again, I personally prefer the C corporation If you're planning on setting up a nonprofit organization, a tax-exempt nonprofit organization particularly, you will have to set up a C corporation. You cannot set up an S corporation. And just the flexibility that a C corporation offers as far as shareholders. Like I said, you can have foreign shareholders in a C corporation. You can also have other corporations as shareholders of your corporation. You can also have limited liability companies as shareholders of your C corporation. And whereas for an S corporation, you're limited to those 100 shareholders in California that that have to be U.S. citizens or permanent legal residents. Um, so, so usually C corporations though are geared towards larger corporations that plan to have a lot of shareholders and maybe plan to go public at some point, whereas S corporations are limited to a very small set of shareholders, and that in turn can also limit the amount of money you can generate for the corporation because the number of shareholders are limited. Um, but as far as liability issues concerning corporations, for the C corp, well, whether it's an S or a C corporation, the liability protection is much greater under a corporate structure than it is under running your business as a sole proprietor or a DBA. So for a corporation, like I said, a corporation is a separate entity that has this separate income and assets, and that all stays with the corporation and the owners of the corporation. Um, the owners of the corporation are usually only liable for mishaps that happen under the corporation up to the amount they have put into the corporation. So, for example, um, suppose going back to our previous example with the Hair by Claire, say the owner of Hair by Claire decides to set up an S corporation, and she does the formalities and sets up that corporation, and then the client gets hurt from her doing her hair and burns her face with the curling iron, and now the client tries to go and sue Claire personally for this mishap, and the case is going to get dismissed because Claire was only an employee of the corporation Hair by Claire Inc. And therefore, if Claire knows how to do everything, she'll go in and make a motion to dismiss and say that they've sued the wrong person. You have to sue the corporation for this negligence, and that's where that will stand. And now the client will then have to sue the separate business entity, which may or may not have assets, and Claire's personal assets are protected. So if Claire owns her own house and her own cars in her name, but she also has this corporation set up that handles all her business and all business is being done under her corporation, um, the lawsuit, the client will need to sue the corporation that may or may not have any assets. There's many ways that people set up corporations so that the corporation that is operating the business doesn't hold assets. They just lease the assets from another entity. And then Claire has her separate property and her separate assets in her name that client cannot attach. So if that client sues her corporation, she will have to seek payment of that judgment from corporate assets. She cannot then go and try to attach Claire's house because the corporation was the owner of the business, and the corporation would be the one responsible for any acts of negligence committed by the employees. Um, and then again, if the corporation doesn't hold any assets, the judgment creditor is just going to have to sit on the judgment until maybe one day the corporation has assets or income. But um, at the bottom line, they can't go after Claire's personal assets for business lawsuits. But then there's a flip side of that situation. say we now have a situation where Claire, as an individual, is out here driving on personal time and she hits somebody and has a very bad accident and she gets sued for $1 million. And then her car insurance only covers $300,000, and the creditor ends up getting a judgment for $500,000. So now Claire is on the hook for $200,000 on a judgment that now that creditor can go after her personal property, and also that creditor can go after her ownership in the corporation. Because remember, the corporation has shareholders, and say in this situation, Claire is the only shareholder of the company, so she owns 100% of those shares. So now that creditor can attach her shares in the corporation and then take over Claire's corporation and then take over any assets or income that's inside that corporation. So that's the drawback with the corporation situation, because although the owner of the corporation will not be liable for corporation debts and liabilities, if an owner of a corporation has personal debts and liabilities, that creditor can take over that corporation and can then get into the assets that the corporation holds. So a lot of people think in their head, oh, I'm going to put all my assets in this corporation, thinking that they're going to be protected, but they don't consider that a creditor can take over your shares in a corporation and take over your corporation. So that's just something to keep in mind about the drawback in setting up the corporate structure if you do plan to have corporate assets or put money and income and assets into a corporation. And so this is where another structure called the LLC may help you. But first, let me briefly talk about the tax aspects of the corporation. Um, C corporation, again, is my preferred corporate entity. I mean, my preferred business entity vehicle. However, C corporations can be seen as a double-edged sword, because there's a lot of different factors that go into a C corporation that can either help you tax-wise or can cause you to end up paying more taxes tax-wise, primarily because C corporations are subject to a concept called double taxation, where suppose after all of your allowable expenses, your C corporation has a profit of $100,000. That profit will need to be reported on tax form 1120, which is the tax form that C corporations file with the IRS, and that profit will then be subject to income tax, just like a person. And thankfully, thanks to Trump, I know we don't want to thank Trump for a lot, but if you're a corporation owner, Trump did come through with a 20% cap on corporate income tax. So as opposed to 35%, that was the max income tax on a corporation before Trump reduced it to a cap of 20%. So you're looking at $20,000 in taxes that you're going to pay on that $100,000 profit on a C corporation. And then also, you probably will have a state tax liability on corporate income tax as well, but that all depends on your state, because some states like California do tax corporations on income tax and some other states might not. So you have to check with your state to see how that works. But at the end of the day, you will get charged 20% on that corporate profit of $100,000. And then if the corporation elects to expend that other $80,000 out in dividends to the shareholders, they too will be taxed on that $80,000. So if Claire is the 100% shareholder in her corporation and she set up a C corporation, the S corporation is going to be different. Excuse me. But if she does set up a C corporation and receives that $80,000 in dividend income, she also will be taxed again on that $80,000 income that she receives as a dividend from the corporation. So that's where the double taxation comes in. And this is in addition to all the some sales taxes some corporations have to pay, and also the employment taxes that many corporations have to pay. And I know people see a lot of corporations that end up that you see on the news, oh, they didn't pay any taxes. They didn't pay any taxes. Well, they leave out the part where they didn't pay income taxes, but they do end up paying a lot in employment taxes. Because, I mean, this is a different topic for a different day, but usually corporations are going to have employees and they're going to be required to pay the employees the salary and also withhold unemployment and Social Security and Medicare tax, also all called payroll taxes. They're going to have to withhold all that and actually pay those taxes out too. And this is why they usually are able to reduce their profits at the bottom line profits, because they pay most of the profits out in salaries to the officers and directors and to the other employees. And so then they don't have as high of a profit to report on the 1120, which results in them, having no income tax liability, but they still had employment tax liability, sales tax liability, fuel tax liability. If you like run a trucking company, you'll also have to pay fuel tax. So there's a variety of other taxes that some corporations do have to pay. So it always trips me out when I hear people say, oh my God, they didn't have to pay any in taxes, because the media only tells you about the income tax. They don't talk about how much employment tax a lot of these companies pay. And if you are setting up a corporation or an LLC, the government does expect that you at least are paying your officers and directors a salary. So you're going to have that income and that employment tax at some point, because you do really actually need to report the salary of the officers that run the corporation. Now, and then also on top of that, again, you might have the state income tax that you have to pay as well. So, so I mean, the taxes that a C corporation has to pay could be astronomical, but there are ways to limit that tax liability, because most corporations are going to have high expenses. They're going to have high salaries that they have to pay. If their profits start getting up there, they're going to be paying out salaries, and then at some point they may need to pay the shareholders the dividends. Um, as far as the S corporations go, um, a S corporation, when you make that election to be taxed as an S corporation as opposed to a C corporation, you can eliminate that double taxation issue that may arise with some corporations if those corporations have profits. So, whereas on a C corporation, you're going to pay income tax on that $100,000 at the end of the year if you're showing a $100,000 profit. And then if you disperse that profit out to the shareholders, they're going to pay dividends tax on those dividends according to whatever tax bracket they're in and how their taxes end up coming out. For an S corporation, you cut out that initial income tax on the corporation. The S corporation files a form 1120S, and then any income or any losses are reported on that 1120S and then passed through to the shareholder as income or loss on their 1040. So a S corporation will issue a Schedule K to the shareholder of the S corporation, and so Claire then would take that whole $100,000 as income on her 1040, and depending on if she has additional income from another source or if that's the only income she has, then she's going to get just taxed once on that $100,000 at whatever tax bracket she has. And I think for individuals, the highest tax bracket is still like 35%. So this is where a corporation structure, a C corporation structure might be better, because because you're paying 20% max tax as opposed to 35% if you take all of that income through a S corporation, and that puts you in the highest tax bracket for individuals, which I believe is still at like 35%. I have to check that because I'm not sure. But just keep that in mind. Also, so going back to the liability issue, we'll talk about this new concept called the limited liability company, which is also known as the LLC. I know a lot of people rave about the LLC. The LLC is great, but understand that the LLC is relatively new concept that is a state created concept. The Internal Revenue Service does not recognize the LLC as a separate entity. It's all a state created concept. Some states have more favorable rules for LLCs, whereas some states just like for instance in California, there is an $800 minimum franchise tax that all business entities must pay each year in advance. But for corporations, they give you a year break where you don't have to pay that $800 for the first year that you set up a corporation. But for an LLC, you have to pay that $800 right off the bat. They don't give you a break for that. So just keep that in mind. As far as the LLC goes, like some states are more favorable for LLCs, whereas some states are more strict with them. And the IRS does not recognize the LLC as a separate entity. The good news is you can elect to have the LLC taxed as a corporation. Once you set the LLC up properly, you can then file a form with the IRS that will allow you to have your LLC taxed as a C corporation. And then you can also file additional paperwork to have the LLC taxed as a separate, as a S corporation, the way that an S corporation is taxed differently from the C corporation. And remember, we talked about the double taxation with the corporation structure, the C corporation structure, versus the pass-through tax benefit of the S corporation structure. So if you don't make that election, then the LLC for IRS purposes is just treated as, well, if it's a single member LLC, where it's just you as the owner, the managing member, the member of the LLC. If it's just you, then the IRS is going to treat the LLC as a sole proprietor. And if there are two or more people that are members of the LLC, then they're going to treat and tax that LLC as a partnership. Again, unless you make that election to be taxed as a corporation, and then you can make a further election to be taxed as a S corporation. I don't think a lot of people know that, so it's important to know, because just depending on your situation, you might end up tax-wise with the same situation you would end up with operating as a sole proprietor. But the main benefit of the LLC is that the main benefit of the LLC is the high level of liability protection an LLC might be able to offer for when it comes to a member of an LLC having personal liability for like a car accident or for a high debt owed to someone. The LLC is great in being able to protect assets being held in the LLC from those creditors. So again, going back to Claire, we discussed how Claire's personal assets could be attached if she operates as a solo proprietorship, or which is AKA doing business as or under a fictitious business name, and how she can also end up losing her corporation if she has a personal liability outside of her business that causes the judgment creditor to be able to take over her corporation. We also talked about how the corporation, the creditor cannot get to her personal assets for activities operated, engaged in under the corporation structure. They can only go after what's inside the corporation for business liability. However, if she has a car accident, then that changes that whole scenario. And now a judgment creditor on her personal side can then go after her business assets by taking over her shares in the corporation. So this is where the LLC is great because LLC offers what is called a charging order, where that will limit the ability of a personal judgment creditor, such as Claire, who gets into a car accident and has a $500,000 judgment against her. So if Claire has all of her property under an LLC and Claire ends up with the judgment against her for $500,000, that creditor is going to have a very hard time getting the assets that are being held in the LLC, with the LLC being in place there. So, say Claire has this car accident and has her has her corporation set up as Hair by Claire Inc. And then she has a separate LLC called Everybody Wins LLC. And the LLC has most of the assets inside the LLC. The Hair by Claire Inc. only employs Claire, pays her the employment salary, and the corporation is not holding any assets. The corporation is leasing the building where Claire does hair from the LLC that owns the building, and the corporation is leasing the equipment that from the LLC that is in the business of leasing business property to other businesses. And then Claire just doesn't have anything in her own name. She's everything else is in the LLC. So now Claire gets into this car accident, and and this judgment creditor gets a $500,000 judgment against her. And yeah, the LLC has a bank account also that has about $1 million in it, and Claire is a 25% owner of a member of the LLC, and so therefore, 25% of that $1 million she put in $250,000. So once the judgment creditor gets the judgment, they may try to attach Claire's 25% interest in the LLC. However, all they can get at that point is a charging order. It's called a charging order that will only allow the creditor to get at the assets or Claire's portion of the assets that are in the LLC only if the LLC distributes assets or income to Claire while that charging order is effective. So if the LLC never distributes income or assets to Claire during that time period, the judgment creditor will not get anything, and in fact, they'll get a tax bill for Claire's share of the taxes that may be due on phantom income that the LLC may generate. So most creditors don't really want to have that liability, especially knowing that there's a high chance that they'll never get anything out of that LLC property, because this is how the LLC protects assets from a judgment creditor that someone has personally against them. Now, on the flip side, if all the assets are held in the LLC and the LLC is doing business like real estate construction, and someone falls off a house and dies, and now they have a $10 million judgment against the LLC, then yeah, all that property inside the LLC is going to they're going to take it. But that's why usually a lot of people set up LLCs for the purpose of holding assets, renting out assets, leasing business equipment to corporations or to individuals or partnerships, and they don't really engage in any kind of um, high risk activities that would subject the LLC business entity to being sued for something. And so, whereas the better bet is to set up the corporation, and the corporation might be engaged in high liability activities, and then if that person sues the corporation and there's no major assets in the corporation because the corporation is leasing the assets from the LLC, renting the equipment, they have nothing to go with. And then if they try to sue Claire personally and she doesn't hold anything in her name, they're going to be stuck. And this is what people usually call making yourself judgment proof. But that, again, is another topic that can go on forever and will be the topic of a future video, maybe. But getting back to how people can set up an LLC. Basically, setting up an LLC is the same process as setting up a corporation. You just file what's called articles of organization with the Secretary of State or whatever entity your state refers to it as. And just let me walk back a little. You're not limited to setting up a LLC or a corporation in a state that you don't live in. I mean, in a state that you live in, you can set up an LLC or a corporation anywhere in the United States. The only thing you need to be careful about is that it's possible that most states are going to require that if you're doing business in their state, even if you're not organized and set up in their state, you're going to have to file you're going to have to register your corporation or LLC in that state and still be on the hook for the same requirements that someone who formed a corporation in another state, I mean, inside that state would be responsible for. Like for California, like I said, every year in California, you have to pay the $800 minimum franchise tax once you set up your entity. And some people try to go set it up in Nevada and then still do business in the state of California, but you can actually open yourself up to some problems trying to do that, because even if your corporation is set up in Nevada, if it's doing business in the state of California, you have to register as a foreign company in the state of California and still pay those franchise taxes. So, I mean, it just depends on your goals and what you are planning to do with your company, but just keep that in mind. I mean, a lot of people like to set up their corporation in Delaware, but again, if your business is doing business in a different state, you're still going to have to register it as a foreign corporation and comply with whatever state rules there are to maintaining that corporation in that state and to doing business in that state. And I'm going to talk more about the problems that may arise in just a moment. I just want to get back to how to form the LLC. So you'll file those articles of organization with the Secretary of State to set up your LLC. And then once you get those articles of organization filed, you then will go get your EIN number, and then you've set up your separate entity LLC, and then you can start the bank account and doing everything under the LLC. Then you need to decide if you're going to elect to have your LLC be taxed as a corporation, and then if you're going to have it elect to be taxed as a S corporation, you'll just have to make up your mind about how you want to set that up. But if you don't make those elections, just remember that tax-wise, you'll still be treated as a sole proprietorship or as a partnership for IRS purposes once you set up that LLC, unless you make the election to be taxed as a corporation. And then instead of having shareholders, The LLC is going to be ran by members. People will be issued membership certificates into the LLC, and the LLC can either have managing members or managers who are not members. Um, or managing members would be members who manage the LLC, and then the managers are just members who are not. I mean, the managers are just people who will run the LLC who are not owners in the LLC. And the LLC, like a C corporation, is not limited to the number of members they can have, and there can be foreign members. There can be They can have corporations that are members of the LLC. Other LLCs can be members of the LLC. There's a way you can set up things so that it's all stacked, and the LLCs are not limited to just 100 human beings that are U.S. citizens or permanent residents, like an S corporation is limited to. So, so again, getting back to the scenario of the lawsuit against Claire, um, she's gonna win by being a member of the Everyone Wins LLC, as long as everything is set up properly and you take the steps to structure everything so that assets are not at risk. I've seen a lot of people also even set up just different LLCs for each property, like especially with a real estate company. A lot of times they will set up separate LLCs to hold each separate property, and then they might have a corporation set up to hire employees and pay the payroll, and just lease property from a different LLC, lease the cars from the LLC. They set up a different LLC to hold the cars. I mean, that's high level structuring. I don't know if most people need to go that far, but that is something that a lot of people do just to keep the assets protected from personal creditors that might try to come through and take everything. And again, with the corporation setup, if you're going to put all your assets in that corporation, you're putting them at risk to be taken by a judgment creditor who can take over all your shares. But as far as an LLC goes, that judgment creditor cannot take over your ownership interest in your LLC. They can only get that charging document that can actually lead to them having a tax liability as opposed to them getting your assets. So, um, in closing, I want to remind you that there are various due diligence issues that may arise that you need to be on top of in order to keep all of this maintained and to keep these protections in place. Because if you don't comply with those state requirements for maintaining your corporation or your LLC, there's this concept that's called piercing the corporate veil, which will allow a creditor to ignore your business entity and argue that your business entity was just an alter ego of you, and therefore come get everything. They're going to take your personal property, they're going to take your business property if you don't follow the proper due diligence that's required every single year to make sure your corporation or LLC is legit. And I often see people who, I want to set up a corporation, or I want to set up an LLC, and they set it up and then they don't maintain it like they need to maintain it. They don't pay the franchise tax. They don't pay the annual reporting fee. In California, every year a corporation has to pay $25 statement of information fee, and they also have to pay that minimum $800 franchise tax. And if you don't, then the state is suspending your corporation. And I'm going to talk to you more about what happens when that happens. But as far as being able to keep a business entity alive, quote unquote alive, you have to make sure that you comply with the annual due diligence requirements for your state. And you also need to make sure you set up what's called bylaws that are basically the governing document for your corporation, and also for the LLC that you set up an operating agreement that establishes the operations of your LLC. You also need to have shareholder agreements for corporations or membership agreements for LLCs. And then also, at a minimum, every year you have to have an annual meeting of the board of directors and or annual meeting of the managing members. That meeting has to be recorded in what's called minutes, and you have to keep those records on file because at any point someone can subpoena those documents, somebody can ask to inspect those documents, and if you don't have those things in place, uh, a judgment creditor can argue that your LLC or your corporation is not legit, and then they can do what's called pierce that corporate veil, and all of your assets then will be subject to being taken by the judgment creditors, or even by just creditors that you might incur, from tax debt or from credit card debt or what have you. So it's really important to get up to speed on your state's requirements for annual it's called due diligence and annual reporting, so that you make sure you file the proper tax returns for the state and for the IRS, and that you comply with the due diligence requirements for that state. If you don't comply with annual reporting requirements in the state of California, the state of California will suspend your corporation or your LLC and put you in a FTB suspended status. And once you're in that status and your corporation is in that status, um, the corporation will not be able to defend itself in any lawsuit that's filed against it. And on top of that, if you continue to engage and conduct business under that business entity while it is suspended, that constitutes a misdemeanor, and you can face criminal charges for operating a suspended business. Which, I mean, I haven't really seen that happen a lot, but that's a possibility that you might face in running a suspended corporation or LLC. And then if you fail to pay that $800 California franchise tax each year, that situation can really spiral out of control. They'll start adding penalties and interest to the balance, and the state of California is merciless when it comes to that. When it comes to that franchise tax, once you don't pay it, they suspend your corporation. It starts to add penalties and interest, and that escalates to about a $2,000 or $3,000 bill. Then you can't even dissolve your company at that point until you pay that money. So now you have a suspended corporation that every year is accumulating taxes and penalty and interest that you'll never be able to pay. And then if your business then gets sued, you're not going to be able to defend it because the California Franchise Tax Board has suspended your corporation, and once it's suspended, you're not able to defend the company in a lawsuit, and then at that point, a creditor could easily ask the court to pierce the corporate veil and take all your business. And I really don't think a lot of people understand that that's how it goes down, but it's really important to stay up to date on those franchise taxes, on those annual reporting requirements, because you can set all this up and then still lose everything if you don't comply with the requirements. Um, so, with that being said, I just always urge anyone who wants to open up a business and set up a business entity to always be sure to, at least at the very least, just consult with a business attorney and also with an accountant. Um, it's probably more advisable to just have a business attorney on retainer if you plan to set up a business entity, and also have an accountant on deck from the beginning so that you comply with all the tax requirements and that everything is set up right and not wrong, and that everything is maintained properly. A lot of businesses go under for the very simple fact is that they get caught up in tax problems. that people are not aware of because they hear a seminar and they say, oh, this person said go set up an LLC and then I'm going to have all this and that and everything is going to be all this. And then they leave out the other part about what you need to do to make sure it is maintained. And so then people go out here, run out here and file their articles of organization and create this new person, this new entity, and then they don't maintain it. And then here come the tax authorities. It might not catch up with you immediately, but over time, and especially in California, they start sending you those notices and those bills, and by then it's out of control, and that's how a lot of people end up losing their business and missing out on the opportunity, on the benefits that the business can provide, because like I said, the business gets suspended. Now you get sued. You can't defend yourself unless you're going to pay like $4,000 to revive your company, and it can get out of hand really fast. So I always strongly urge people to consult with an attorney, a business, specifically a business attorney, probably a tax attorney, and also an accountant, to make sure that everything is set up right. And also, just because there's so many loopholes and so many avenues in the corporate and tax games, you probably want to have someone knowledgeable on deck that can help you and guide you into how to maintain and take and constantly take advantage of all of the benefits that you can get by having a business entity like a corporation or an LLC. As we've seen recently with COVID, there's been a lot of grants that have been dished out to people who have business entities set up. And, you know, a lot of people missed out on that opportunity. Instead of just getting $600, a lot of people will get thousands or even tens of thousands, hundreds of thousands of dollars, because they do have a legitimate business that was set up properly and did all the paperwork. And so now they qualify for those grants and loans. So again, just make sure to be thoroughly researched and to really try to speak to a professional who knows what they're doing and can guide you on how to really take advantage of the corporate structure, how to really take advantage of the LLC structure, how to set things up on a much larger scale that will really provide you with the most optimal benefit and keep you as an individual protected from creditors and protected from, having all your assets taken. Um, on a last note, I just want to touch on the partnership structure. I know many law firms are structured as partnerships, and to me, I don't know. I think that is like the worst way to set up or run a business at all. I mean, partnerships are just like sole proprietorships or DBAs, where two or more people come together under a DBA and agree to share in the profits and expenses of a business enterprise. I just think that it's not the best way to go unless you're going to put a partnership together between two corporations or two LLCs or a combination of LLCs or corporations or something. But doing a partnership as two individual human beings, it just makes no sense to me, because under a partnership, you're going to be responsible for anything that your partner does, especially if you're a general partner. You are going to be on the hook for anything that your general partner does, and now your personal assets are going to be subject to attack from partnership debts and creditors, and you might not have even had a clue or had anything to do with what your partner just did to get the partnership bound into a creditor coming after your personal stuff. So I just don't understand why anybody operates as a general partnership. You might be able to have advantages of operating as a limited partnership if you are the limited partner, but if you are a general partner in a general partnership, it just makes no sense to me to operate that in that manner. It makes no more sense than operating as a sole proprietorship and having just all of your personal assets out there at risk, not only for your mishaps, but the mishaps of somebody else that is associated with you that you may or may not have control over, and now they're coming after your personal property. So I'd never understood the partnership concept. I mean, it does have advantages from a tax standpoint because there's so many ways you can structure a 1065 partnership return. I know those returns are extremely complex and they can get really involved, and you can allocate different things at different times to different people. But from a liability standpoint, I see no purpose of operating as a human under a general partnership at all. It's never been a good idea to me. But a lot of law firms do operate as partnerships, but I won't be. But with that being said, I hope you all have learned some new things in this video, and will take some time to read up on the issues and the various topics I've discussed here, and also possibly consult with a tax attorney, a business attorney, or an accountant about the pros and cons of each business structure, and how you can use the corporate structure to maximize your tax benefits or limit your tax liabilities while you operate your business, and how you can protect your assets from creditors by setting up the proper vehicles to conduct business and to protect yourself. Um, and again, the first step in getting into the game is to set up an entity so that you have the vehicle to play the game, and then at that point, your opportunities are open to getting all the benefits and being able to structure things that will help you prosper. Um, so please like this video. Please share this video with anyone you think or may be interested in the information. And please also hit the notification bell to be notified when the Diva Lawyer Social Club presents future videos. And please also feel free to leave your comments or questions in the comment box below. And we'll look forward to seeing you next time. Have a good day.